And the number one story this hour trending today in the USA. It was a partial victory for President Trump and his travel ban, depending on your point of view. The Supreme Court ruling yesterday parts of the executive order can go forward. However, the High Court will not hear the broader case until the fall. Byron Henry, attorney and constitutional scholar, joining us now on Trending Today USA. Byron, is this a partial victory or is it a full victory or a vindication?
Well, Arnie, it's much closer to a full victory and vindication than a partial victory, because if you remember when President Trump amended his executive order, created a waiver provision to allow persons that had a connection with the United States to come to the United States, students, potential employees, as well as family members. So the Trump administration foresaw that there could be a problem with cutting everyone out. What they were concerned about was everyone that had no sponsors or connection with the United States, and that's exactly what the Supreme Court's ruling does, is allow the temporary travel ban to go into effect for every single person attempting to travel from those 6 countries for the next 90 days, except those that can either get visas or have a personal connection with family, employment status, or student status. They've already been admitted to a university, for instance. Of course, they also stayed the refugees. They found that President Trump did have the authority to reduce the number of refugees to 50,000, something that the lower court said he did not have the authority to do. So it was basically, although technically it was a partial victory, across the board it is a vindication of the policy that the Trump administration put forward.
I'm surprised that they didn't just overturn the court and move on. They want to hear the entire case. And based on what a number of attorneys have said, there is a specific statute that specifically says the president can, in fact, do this. What is there to hear?
Well, there's 2 reasons why they didn't hear it initially. Number one, the Trump administration did not ask for expedited consideration of the case. Mm-hmm. They gave the Trump administration basically what they asked for. That's number one. But number two, if you think about it, the Supreme Court is telling the Trump administration, you have your 90 days. The temporary travel ban is set to expire in 90 days from the date we ruled. Go ahead and do your vetting procedures. Come up with new procedures at the Department of Homeland Security. You don't need this travel ban once you come up with the new vetting procedures. And in effect, the travel ban issue may not even be live whenever they hear the court. So they actually kick the can down the road to a position where they may not even have to rule on the merits. And the reason they don't want to do that is because anytime you have a clash between branches of government, the Supreme Court, the judiciary, likes to avoid clashes with the executive or legislative branch if it can avoid them. And in this case, I think the Supreme Court thinks it can avoid a problem by kicking the can to October.
You know, it does seem like the Supreme Court does that a lot. They don't want to get involved in certain measures of our society and certain measures of our government, and they do kick the can down the road. And I think a lot of people look to them for the answer, and they don't necessarily get it.
Well, in fact, the Supreme Court, in the kind of a judicial restraint situation, has a provision, a doctrine called the doctrine of constitutional avoidance. And that doctrine is court-created. It is basically, if we can avoid a constitutional issue or a constitutional crisis, we are supposed to avoid it if we can. And in this case, I think that they are basically putting it off till later. They will address it if they have to, but I don't think there's going to be a lot to address come October with respect to the travel ban. I expect that it's going to be lifted, and there'll be new vetting procedures in place for these 6 countries.
And so at that point, it's kind of a moot point once we get there.
The only way it won't be moot is if someone specific in this group, a student, a family member, has attempted to come into the country and been denied.
Yeah.
If they have been denied, then there will be a live controversy. But like I said, with the waiver provision and the direction to the Department of Homeland Security to let the people in that have connections to the United States, I see a very outside chance there's going to be anything for the Supreme Court to decide later this year.
Interesting. Byron, just a little bit of a curveball. I'm curious, have you seen the Supreme Court rule on anything this year that surprised you?
Not particularly. I thought the 7-2, I'd actually predicted a 7-2 split on the church and state case.
Yeah.
That came down, because I believe that Kagan and Breyer would sign on with the conservatives with respect to this religious rights case. What's going to be interesting is this is a very strong religious freedom court. Justice Gorsuch joining, of course, Thomas, Roberts, and Kennedy have always been strong religious freedom. But they took a case on the cake baker case with the LGBT, the same-sex couple where the cake artist decided not to serve the same-sex couple. That is where this newfound same-sex marriage marriage right and these anti-discrimination statutes are going to collide head-on with the court's religious freedom jurisprudence, and we're really going to probably see a fractured court. It's going to be a tough case, and I see that as being one of the bigger cases next term.
It always does seem they have one marquee case every year, and that may be the marquee case for next year, I suppose. All right, Byron Henry, attorney. Go ahead, Byron.
Oh, I was just going to end the immigration cases that were deadlocked 4-4, so they ordered them re-argued with Justice Gorsuch on the court. There were two big immigration cases that they couldn't reach a consensus on, so they're going to be re-argued in the fall, and it looks like Justice Gorsuch will be the deciding vote in those. So between the Cake case and the immigration cases getting re-argued, we're probably looking at a couple 5-4 cases next term.
Before I let you go, Byron, now that you bring that up, there have been a number of 4-4 cases after Antonin Scalia had passed away. I'm curious, there was one in California about teacher unions and whether or not somebody was forced to be a member and forced to pay dues, and that ended up being a 4-4 tie with Gorsuch on the court now. That might change that. Is that case going to come back?
Yes, there actually is a case that's coming back. It's in one of the circuit's courts. I was just reading an article that it should be primed and decided on this summer, which means they'll do a petition for cert, and there's a good chance the exact same issue will be back before the court with a full 9-member court next term if they're interested in taking it.
Interesting. All right, Byron Henry, attorney and constitutional scholar. You will find him at solidcounsel.com. Thank you, Byron. Appreciate it.